dear students, today we will be dealing with laws relating to prevention and control of water pollution in India. Let us see the objectives of this lesson. To understand the Water Prevention and Control of Pollution Act 1974 and to understand the structure and functions of the pollution control boards, to understand the legal aspects relating to marine pollution and to understand the coastal zone regulations in India. Let us first deal with the introduction of this Water Prevention and Control of Pollution Act. The Water Prevention and Control of Pollution Act 1974 was enacted for the purpose of prevention and control of pollution of water. Pollution of streams, rivers and other water courses reduce the availability of potable water. In addition, it caused deterioration in the quality of vegetation and other living creatures in water. The Water Prevention and Control of Pollution Act 1974 follows the broad scheme of control with the pollution control boards as the nodal agencies for its effective implementation. The objective of the Water Prevention and Control of Pollution Act 1974 as stated in the preamble is to provide for the prevention and control of water pollution and for the maintenance or restoration of wholesomeness of water through the establishment of water boards. Water pollution means such contamination of water or such alteration of physical, chemical or biological properties of water or such discharge of any sewage or trade effluent or of any liquid, gaseous or solid substance into water, whether directly or indirectly as may or is likely to create a nuisance or render such water harmful or injurious to public health or safety, or to the life and health of animals or plants of aquatic organism. Let us deal with the machinery under the Act, the Central Pollution Control Boards and State Pollution Control Boards. The Water Prevention and Control of Pollution Act 1974 establishes the central and state boards for the prevention and control of water pollution. The constitution and functions of the boards are: it consists of one full-time chairman to be nominated by the central government. He should have special knowledge or practical experience relating to environmental protection. Not more than 5 officials to be nominated by the central government. Not more than 5 persons to be nominated by the central government from amongst the members of the state boards. Not more than 3 non-officials to be nominated by the central government to represent the interest of agriculture, fishery or industry or trade, etc. 2 persons to be nominated by the central government to represent the companies or corporation owned, controlled or managed by central government, and 1 full-time member secretary to be nominated by the central government. He should possess qualifications, knowledge and experience of scientific and engineering or management aspects of pollution control. The board is required to meet at least every 3 months. If a business of urgent nature is to be transacted, the chairman can convene the meetings of the board at any point of time. For the purpose of performing its functions under this Act, the state board or any authorized officer may obtain any information from any person, industry or establishment regarding the construction, installation or any disposal system. The state board or any authorized officer shall have the power to take samples of water from any stream or well or samples of any sewage or trade effluent for the purpose of analysis. The result of the analysis of such sample shall be admissible in evidence only if the following procedure is followed. Any person authorized by the State Board shall have a right to enter any place for the purpose of performing any functions of the board, or for the purpose of examining any plant, record, register, document, or any other material object, or conduct research if that provides the evidence of the commission of an offence under this Act. There is a restriction on new outlets and new discharges. No person shall, without the previous consent of the State Board, establish any industry or any treatment and disposal system which is likely to discharge sewage or trade effluent into a stream or well, sewer, or on land, and bring into use any new outlet or the discharge of sewage, or make any discharge of sewage. Under section 28, any person aggrieved by an order of the State Board may appeal within 30 days from the date of communication of the orders to the appellate authority as may be established by the state government. A new provision, section 33A, was added in the year 1988. Under this provision, the board may, in exercise of its powers and performance of its functions, issue any directions to any person, including those for the closure, prohibition, or regulation of any industry, operation or process, or the stoppage or regulation of supply of electricity, water, or any other service. Certain offences are mentioned under the Act. The penalties have been prescribed for violating different provisions of the Act. For failure to give information as required under section 20 of the Act, the punishment is imprisonment, which may be extended to 3 months, or fine, which may be extended to 10,000 rupees, or both. In case failure continues, an additional fine which may be extended to 5,000 rupees per day during the period failure continues. For violation of orders or any direction prohibiting discharge of any polluting matter into stream or well or land under section 32, or violation of court order, restraining pollution of water under section 33, or for violating the directions of the board under section 33A, the punishment prescribed is imprisonment from 1 year 6 months to 6 years and fine. If the failure continues, an additional fine which may extend to 5,000 rupees per day during the period of failure. If the failure continues for beyond 1 year, then the imprisonment shall not be less than 2 years, but which may extend to 7 years and with fine. For permitting any poisonous, noxious, or polluting matter into any stream, well, or land, the punishment shall be imprisonment for a term of 1 year 6 months to 6 years and with fine. For pollution of stream or well or land by discharge of sewage or trade effluent, the punishment shall be imprisonment for a term of 1 year 6 months to 6 years and with fine. Section 45 of the Act provides enhanced penalty after previous conviction, which shall be imprisonment for a term of 2 years to 7 years and with fine. Marine pollution. Marine pollution is defined as discharge of waste substances into the sea resulting in harm to living resources. Pollution of estuarine water is spreading rapidly because of the ever-growing population density along coastal areas and intensification of coastal activity along the coast. Without the sea, this planet would be uninhabitable. The sources of marine pollution. There are 5 main sources of marine pollution, which are deliberate, operational and accidental discharge of ship-borne pollutants, disposal of domestic sewage, industrial effluents and agricultural waste, interference with the marine environment from the exploration and exploitation of marine resources, disposal of radioactive waste resulting from the peaceful uses of nuclear energy, military uses of the sea. The effects of oil pollution. The most important effect of oil is that of the destruction of wildlife and habitat. Tourism is affected to a great extent. Marine organisms by oil pollution become carcinogenic agents entering into human organisms by consumption of sea fish. This poses a hazard to man himself. Operations removing oil from the sea affected by oil pollution is costly. Spoiling of the beaches and coastal amenities, destruction and injury of seabirds. Let us deal with the marine pollution in India and its situation. India has a 6,000 kilometer long coastline and an extensive continental shelf. India's coastal population along with the industries discharge large quantity of waste to the sea. The causes of marine pollution in India are pesticides and insecticides which are used in agriculture and tons of synthetic detergents which are consumed for washing and cleaning purposes in India. Domestic sewage is as responsible as industrial effluents for pollution. Oil spills and washing from super tankers and blowouts from offshore oil platforms pose a real threat to harbors and beaches, destroying all life and spoiling places of recreations and fish landings. The marine resources have been of prime concern under the Constitution of India. The land, minerals and other things of value underlying the ocean within the various zones such as the territorial waters or the continental shelf or the exclusive economic zone vests with the Union of India under Article 297 of the Constitution. The legislations on protection of marine environment, the territorial waters, continental shelf, exclusive economic zone and other maritime zones, Act 1976. With the increasing awareness of the economic benefits to be gained from the sea and seabeds, certain coastal states have claimed jurisdiction over the vast areas of sea around them. The third conference of the UNCLOS resolved the inadequacies and evolved a regime for the international seabed area. In conformity with the existing trend the world over, the Government of India enacted the Maritime Zones Act on 25th August 1976. This act came into force on 15th January 1977, bringing the entire exclusive economic zone, an area of 2.01 million square kilometers, within our national jurisdiction. The territorial waters extend 12 nautical miles from the defined baseline. The continental shelf is the natural prolongation of India's land territory to the outer edge of the continental margin, or 200 nautical miles, where the continental margin does not extend up to that distance. The exclusive economic zone extends beyond the territorial waters over a distance of 200 nautical miles. The Act asserts India's sovereignty over the natural resources in the continental shelf and exclusive economic zone. Section 6 Clause 3 Clause D and 7 Clause 4 Clause D confer exclusive jurisdiction on the central government to preserve and protect the marine pollution within the continental shelf exclusive economic zone. Coastal Regulation Zone Notification 1991 and its amendments. The legal regime of coastal zone management in India came into force in the year 1991. The central government issued the Coastal Zone Regulation (CRZ) notification by the Ministry of Environment and Forests in the year 1991. Let us deal with the classification of the coastal regulation zone. For regulating development activities, the coastal stretches within 500 meters of high tide line on the landward side are classified into 4 categories, namely Category 1 CRZ1. Areas that are ecologically sensitive and important such as national parks, marine parks, sanctuaries, reserve forests, wildlife habitats, mangroves, corals, coral reefs, areas close to breeding and spawning grounds of fish heritage areas, areas rich in genetic diversity, areas likely to be inundated due to rise in sea level consequently upon global warming, and such other areas as may be declared by the central government or the concerned authorities at the state or union territory level from time to time. Area between the low tide line and the high tide line. Category 2, which is CRZ2. This category consists of the areas that have already been developed up to or close to the shoreline. Category 3rd, CRZ 3rd. This is related to the areas that are relatively undisturbed and those which do not belong to either Category 1 or Category 2. These will include coastal zone in the rural areas, developed and undeveloped, and also areas within municipal limits or in other legally designated urban areas which are not substantially built up. Category 4, which is CRZ 4, this category belongs to coastal stretches in the Andaman and Nicobar, Lakshadweep and small islands, except those designated as CRZ 1, CRZ 2 or CRZ 3. Let us deal with the regulation in the classified zones. CRZ 1, no new construction shall be permitted within 500 meters of the high tide line. However, construction of dispensaries, schools, public rain shelters, community toilets, bridges, roads, jetties, water supply, drainage, sewerage which are required for traditional inhabitants may be permitted on a case-to-case basis by an authority designated by the government. CRZ 2. Building shall be permitted only on the landward side of existing roads or roads proposed in the approved coastal zone management plan of the area, or on the landward side of existing authorized structures. The regulation in CRZ 3 is the area up to 200 meters from the HTL is to be earmarked as no development zone. However, the following uses may be permissible in this zone, which are agriculture, horticulture, gardens, pastures, parks, playfields, forestry and salt manufacture from the sea. CRZ 4, which deals with Andaman and Nicobar Islands. No new construction of buildings shall be permitted within 200 meters of the HTL. Judicial activism. Here we will discuss some of the cases relating to the water prevention and control of pollution. The Supreme Court and High Courts have contributed immensely to the prevention and control of water pollution through their judgments and directions. Some of the most important judgments are mentioned hereunder, which are MC Mehta versus Union of India. In this case, the Supreme Court issued directions to the tanneries to set up effluent treatment plants within a period of 6 months. The court also directed the central government, Pollution Control Board and the district magistrate to oversee the work. Another case is Vellore Citizen Welfare Forum versus Union of India. This public interest litigation under Article 32 of the Constitution was filed by the petitioner against the pollution which was being caused by enormous discharge of untreated effluents by the tanneries and other industries in the state of Tamil Nadu. A pollution fine of Rs 10,000 each on all tanneries in the districts as mentioned in the order was imposed, and same was to be recovered by the collectors or district magistrates. Another case is related to Indian Council for Enviro Legal Action versus Union of India. In this case, a writ petition was filed for the protection of the ecology and for the prevention of the irreversible ecological damage to the coastal areas of the country. The main grievance in the petition was non-implementation of the notification, which was in the year 1991. The court directed the coastal states and union territories to enforce both the notifications and prepare the management plans. It also asked the central government to consider setting up of state coast management authorities in each state or zone and also a national coastal management authority. The shrimp farming case. In S. Jagannath versus Union of India, the court held that shrimp industry is to be permitted only after passing a strict environment test. This case brought into notice for the first time the non-implementation of CRZ notification. A writ was filed in this case for intensive prawn farming in fragile and sensitive areas such as coastal areas and wetlands. The petitioner also sought for constitution of National Coastal Zone Authority to safeguard marine and coastal areas. The allegation of the petitioner was that the coastal states were permitting shrimp farming at a massive scale in violation of EPA 1986 and various other provisions of law. In view of this, NERI was ordered by the Apex Court to submit a report on the status of the problem of shrimp farming in the coastal areas of Tamil Nadu and Andhra Pradesh. NERI submitted a report stating that the coastal areas were highly degraded. In view of the above horrid situation, the Apex Court issued the following guidelines to be followed by the concerned authorities. The guidelines are: the central government shall constitute an authority under Section 3, Clause 3 of the Environment Protection Act 1986 and shall confer on the said authority all the powers necessary to the ecologically fragile coastal areas seashore. The authority shall be headed by a retired judge of a high court. The authority so constituted by the central government shall implement the precautionary principle and the polluter pays principle. No shrimp culture pond can be constructed or set up within the coastal regulation zone as defined in the CRZ notification. The farmers who are operating traditional and improved traditional systems of aquaculture may adopt improved technology for increased production by prior approval of the authority constituted by this order. The agricultural lands, mangroves, wetlands, forest lands, land for village, common purpose, and the land meant for public purposes shall not be used or converted for construction of shrimp culture ponds. The conclusion of the chapter is here as under: the major challenge lies before our country to control the problems of contamination of water. In this regard, citizen action groups and civil societies can be increasingly engaged in making the government accountable in enforcing regulation with regard to industrial effluents and sewage treatment plant for preventing surface and groundwater contamination. Training in various aspects of prevention, abatement and control of pollution to the identified target groups is extremely important. The target groups include officials dealing with planning, funding and implementation of programs for prevention and control of pollution in the central and state governments, the state pollution control boards, the local bodies, operators of industrial and municipal wastewater treatment plants and non-governmental organizations engaged in management of pollution control programs. There is poor assimilation of marine and coastal biodiversity concerns in the Environment Impact Assessment Notification 2006, and there is found to be lack of awareness and sensitivity towards the issue of marine and coastal biodiversity among the judiciary, policy makers, decision makers and administrators. These gaps extend to laws that govern conservation and management, such as the CRZ, which many of the stakeholders are in charge of implementing at the state or district level. The need of the hour is legal review of coastal and marine conservation and biodiversity policies at all levels and take steps accordingly. Dear students, I hope you enjoyed this session. Next session, we will be dealing with the laws relating to air pollution. Thank you.